Some people think patents are all about eccentric inventors with bizarre and impractical notions that have no place in everyday life. But in the world at large, things such as the ring pull used on Coca-Cola cans have enjoyed patent protection. You can also obtain a patent for improving an existing idea, such as adding a Velcro to sports shoes to replace shoelaces. The fact is, the patent system is of value for worthwhile inventions, and it increases the prospects of an economic return. After all, patents are about money, and most people take that seriously. A patent can be described as a legal bargain between the state and the patent proprietor. In exchange for a full technical disclosure of the invention and the payment of certain fees, the holder of a patent is entitled, for a limited period, to an exclusive right in his invention. This is the right to prevent others from manufacturing, selling, imparting, or using the proprietor's patent invention without his authorization in a specific territory or a group of territories. Many inventions are concerned with, for example, engineering, chemistry, computers, and medicine. And many patents are granted for incremental inventions, which consist of small but important improvements to existing products and processes. So it's not necessary to invent something as remarkable as mobile phone technology in order to obtain patent protection. Just about anything can be patented, from a hinge to a satellite dish. But before a patent can be granted, there are certain main requirements which have to be met. Generally, the key requirements for an alleged invention to be patent are that it must be new, involve an inventive step, be capable of industrial application, and not be excluded from protection. These key patentability requirements are acknowledged worldwide as the criteria for patent protection. Be careful. The early disclosure of your invention in written form, such as a published patent specification, a book, a magazine, a report, or an article, prior to the filing of a patent application, will destroy novelty. Disclosures can also be in spoken form, such as the detailed description of the invention on radio or television or in academic papers disclosed at conferences. The invention or any information can become publicly available simply by use, for instance, by manufacturing and then selling the invention, or it could be tested in public. Examples of the fields which are usually either excluded from patent protection or are not regarded as inventions are a discovery, scientific theory, or mathematical method, a literary, dramatic, musical, or artistic work, or any other aesthetic creation whatsoever covered by copyright, a scheme, rule, or method for performing a mental act, playing a game, or doing business. The presentation of information. To find out the specific requirements that must be met to protect your invention, contact your National Intellectual Property Office or a patent attorney or other professional advisors. In general, the best advice is to keep your invention secret and don't tell anybody about it until you have filed your patent application. Usually 18 months after the filing of a patent application, it is published, and the public is made aware of the technical information contained in the invention. There is no need to go to extreme lengths to obtain such technical information, especially when it could all be quite unnecessary. In fact, patents provide the world's largest single source of technical information. There are over 55 million patent documents, a collection increasing at a rate of about 1 per minute, every minute of every day of every year, and patents are normally the first disclosure of technical information. In addition, this vast storehouse of information is available to the general public and can be used by you, regardless of whether you ever file a patent application yourself. The information can be used either to invent and improve technology or to solve technical problems without prejudicing the original inventor's patent rights. It's not commonly known that most patent information cannot be found elsewhere. In fact, over 80% of patent information is unique to the patents themselves and exists in no other forms. A vast amount of information is readily available in the world today. There are also ASEAN optical discs containing patent publications of the ASEAN countries, which are also available from the National Intellectual Property Offices. So, if you don't look at existing patents, you are cutting yourself off from at least 80% of the available information. This is information that could also be used to work out the possible future activities of known competitors and, more importantly, potential future competitors. A patent eventually expires after a set number of years. According to the international practice, a patent expires 20 years after the filing date. More commonly, however, the patent is not kept in force for the maximum term. This means that most of the 55 million patent documents worldwide represent free technology which you can use. But make sure that by using such technology, you do not infringe previous patents which may still be in force. Using patents as a source of information can help you avoid duplicated research and development. Furthermore, you might find that looking at patents can solve a difficult technical problem, or give you inspiration for an entirely new approach. At the least, a search may ensure you do not infringe on other people's patents.